Introduction by members. Madam Clerk.
Introduction of bills. Orders of the day.
Government House Leader.
Thank you, Speaker. In this House, I call continued Committee of the Whole Bill 3, Passenger Transportation Amendment Act. And in the Douglas Fur Room, Section A, I call continued Committee Supply Estimates of the Ministry of Citizen Services, if they complete, followed by the Ministry of Energy, Mines, Low Carbon Initiative.
So it was Bill 13.
That is correct, Bill 13.
Yep. Okay. Committee chairs.
Call the committee on Bill 13 to order. We're working on Clause 1 as amended. Member for Kelowna West.
Well, thank you, Mr. Speaker, and it's nice to see you don the robes again and be back as clerk in the House here. And I'm sure that will, help in terms of the questioning I want to go to on Bill 13. So through the Speaker, to the Minister, I just want to elaborate a little bit more prior to us breaking for lunch. There was the 5 regional areas that the Passenger Transportation Board has segregated where ride-hailing is in British Columbia. He mentioned, I think it was called Lucky to Go and Kaboo, that are approved in the southern interior. I wonder if, for the record, if he could just give us the approved ride-hailing services in each of the 5 regions of the province, and if they're in the 5 regions, does that mean that they actually, like the southern interior, which I understand probably includes Kamloops all the way south, etc., does that mean that Uber, who is in Kamloops, can come to Vernon or Penticton or any of the other places?
There we go. Got it to work. Member from Nanaimo North Cowichan, you wish to say something?
Thank you very much, Mr. Speaker. I seek leave to make an introduction.
Shall leave be granted? Go ahead.
Thank you, Mr. Speaker, and it's appropriate that the whip is sitting over here. I know I'm not supposed to refer to who's in the chamber or not, but I'm a little bit late for my duty, and that usually accompanies a fine in our world, doesn't it? So as I'm being told to hurry up, I'd like the House to help me welcome two guests from Alberta who I've only just met. Emma and Ben Vink from Red Deer are joining us, and they are here to experience the British Columbia Parliament for the first time. So please, members, make them welcome.
Minister, on Clause 1 as amended.
Yes, thank you, Chair. So to the member, let me answer him. I think he's most interested in Region 4, and I can read him the 8 approved companies that operate in the Southern Interior region, which is, as I mentioned, Region 4, Okanagan, Kootenay, Boundary, Caribou. The eight firms are as follows: Inorbis, Caboo, Lucky to Go, Re-Ride, Ripe Rides, Safe Ride Sharing, Tapcar, and U-Ride. I could go through every region, but it is available on the website of both the Passenger Transportation Branch and the Passenger Transportation Board if the member would like to look it up himself, or we can read it into the record.
Kelowna West.
Thank you, Mr. Speaker. For I guess the question through to the Minister, these licenses, I'm assuming that that's how the PTB has approved these passenger-directed ride-hailing services, etc. If these companies are not operating, not fulfilling their duty, is there an opportunity for others to replace the companies that have initially come forward but haven't actually initiated services?
Minister.
Thank you. So the member asked questions that are really more properly directed to the Independent Passenger Transportation Board, who is the decision maker on issues around licensing. What I can say is that the PTB regularly reviews the activity or the inactivity of current license holders. I don't in any way want to speak for the board, but I think we could well imagine that there is some sensitivity to license holders that may have not been active in the market or operating right now during the pandemic, when business volumes were so precipitously impacted. And I'm sure that in the course of their reviews, they get together with license holders and exchange views and are updated on business plans and the planning for the use of those licenses. But I can't be for certain. And again, the PTB is the statutory decision maker in this regard.
Member.
Thank you, Mr. Speaker. Well, I think that, one of the things that I know that I've experienced personally has been that there has been, coming to the Okanagan, maybe going to Whistler, coming to Victoria, that the rental car agencies are struggling to being able to find enough rental vehicles if you're in the marketplace. And I recently was away during our break and couldn't rent a car where I was located after looking ahead during spring break. And so it forced me to have to use alternative methods, and I was able to use, in this particular case, a ride-hailing company that was, I found it to be extremely efficient. I knew when it was coming. I knew what the license plate number, the driver's name, etc. So it all arrived. So to me, it is an improvement in service. But I think that more importantly, it is up to the minister who directs the Passenger Transportation Board to make certain that there's reasonable access for people that are visiting here or live here to being able to access these services. Now this bill, Bill 13, is about public safety, making certain that the drivers have both driving safety checks as well as criminal record checks. But I guess from the standpoint, we wouldn't be talking about this if we didn't have ride hailing. So I guess what I'm really driving at is that there are licensed companies and there are unlicensed companies that are also operating here that he's aware of. I mentioned it in my remarks at the start. And I guess the thing about it is that there's no way of ignoring the fact that ride-hailing is here, even though in a small way in British Columbia. The bottom line is that we're here to talk about the passenger safety today, and I want to just kind of know that there's a couple of companies that are identified in a recent news article that are operating in the Lower Mainland that are unlicensed, and my point really about the issue is that I want to make certain that we can make certain that the public is able to get access to safe, reliable services, whether it's the taxi industry, but we know that the taxi industry has extremely highly costly licensing fees, etc. And secondly, they've been given the opportunity to participate in this, and maybe some of these companies are participants. So I guess my question about this is that how is it that we know, and you mentioned the Passenger Transportation Board, Minister, but I do think that I think that it's fair that the public know what is the effort or what's the uptake in terms of the licenses that the Passenger Transportation Board did issue. We're talking about the drivers that should be operating for that, of the companies that are in existence. Are they actively being used? Is there enough effort going into expanding the service where the need or demand is required?
Minister.
Thank you. There's quite a few questions or points that the member raised in just now, and he raised the issue of unlicensed ride-hail, and we're certainly aware of that. And every day, in fact, the passenger transportation branch of this ministry and the CVSE, working with municipal police, municipal bylaw enforcement, acting on tips from the public, are cracking down on those that are operating dangerous and illegal ride-hails. And I say they're dangerous for a couple of reasons. Obviously, their insurance product would not cover that activity. It's illegal. So the passenger is putting themselves at risk. The driver is putting themselves at risk as well, and tremendous liability, and they're doing something illegal. And it's not always easy to track them. These databases and apps that are downloaded are located offshore, which makes it difficult to completely shut them down. But through a constant effort in Metro Vancouver, because that's where this problem is concentrated, we are making a difference in addressing this problem. And I think people that participate in that industry, illegal industry now, are going to very quickly realize with the growth of enforcement that it is not worth their time and their professional livelihood, if they ever want to work in the ground transportation industry, to work in this black market. The questions around licensees, they are required to operate when they're issued a license. There obviously have been extenuating circumstances during the pandemic where it has been completely uneconomic to operate TNS services in some regions, so they've been not entirely active licensees. They've been periodic, episodic, and they're not required to operate in the entirety of a region. So some of them pick specific cities to locate themselves in. There was an application in early to mid-December from Uber to operate in every region outside of Metro Vancouver. Region 1, they're already there, of course. The Passenger Transportation Board made an independent decision not to grant licenses at that time, but I think in their explanation, I'll try and paraphrase accurately, they said that this is not a decision permanent going forward. It's a decision about the economics of the ground transportation sector today. They felt that this would exacerbate income insecurity for people working both in the TNS sector and the taxi industry to introduce additional services at a time when a lot of people were not making money, and many of them had applied on the taxi side for government pandemic relief grants. So I would say that the application by Uber, in the view of the board, as I understand it, was that it was not never, but not at this time. It's not a good time. So there was a commitment, I believe, to review that. And Uber, of course, has the freedom to apply again for licenses in one or all of the regions that they currently are not licensed in. And then finally, as the member said, this is a bill about passenger safety. The bill that we seek to make permanent, that has existed in transitional regulation and would expire otherwise this fall. The reason why we are trying to put this into law is because it was the product of very thoughtful deliberations and hearings that were conducted by legislators on both sides of the House when we had an all-party committee on taxi modernization and the introduction of TNS. One of the things we looked at was other jurisdictions that did not introduce TNS well. There's all kinds of things on the internet, of 60 Minutes, programs like that, and investigative documentaries about convicted felons literally getting out of prison and having been convicted of served time for violent offenses, becoming licensed Uber drivers because there wasn't criminal background checks. We didn't want to have that in British Columbia. We wanted to have an orderly, gradual introduction, a side-by-side industry where both would flourish. And of course, I think we issued the first TNS licenses, if I'm not mistaken, in December of 2019, and we all know what came in March 2020. We hit the pandemic and lockdown, and we've been through a rough couple of years. So I think you're going to see some of the changes, and certainly I know the member's mayor and Chamber of Commerce and Tourism associations have been writing to the Passenger Transportation Board, presenting their viewpoint that with the tourism economy set to come back and looking at all the data around airport arrivals and departures and things starting to get a little bit more normal and certainly more hopeful, that that real-time information and the data that the Passenger Transportation Board collects and relies on for its statutory decision-making will undoubtedly inform decisions that they could be making, as we speak. I'm not able to direct them as to what they should do. I respect their autonomy and independence in making good decisions for people who work and do business in these sectors.
Member.
Mr. Speaker, thank you for the Minister clarifying those points and answering or trying to answer all my questions. I wanted to just go back to the enforcement part. In this particular article, it talks about the PTB gave out 33 fines in Richmond in 2021. I guess because of the fact that we have the illegal activities taking place, could he clarify what the penalty or punitive actions are? Do they seize the vehicle? Do they impound it or do anything like that? Or is it just a slap on the wrist, a minor fine, and these continue to operate in the gray area? And he mentioned growth and enforcement. If he could describe what growth and enforcement, what exactly is taking place to grow enforcement?
Minister.
Thank you, and thank you for the member to the member for the question. This is a good area of discussion for sure. Not entirely related to the bill, but I think of interest in terms of how enforcement is being done on the illegal ride-hailing industry, because it does come with the risks that I've described around underinsurance or non-applicable insurance, canceled insurance, the risk of the driver who has not undergone a criminal record check, a vehicle that is not properly inspected for commercial purposes. All of those things are what makes this a very risky industry as well. And also it's predatory upon those who have gone through a rigorous licensing process, people who possess a Class 4 license, who purchase the proper insurance product, who are required to adhere to a strict passenger safety regime. So for all of those reasons, we're trying to crack down on enforcement. We do have a fine regime that, compared to many other fines, is actually quite a steep fine tariff on those that are caught. $1,150 fine per offense, and I think the member will know that looking at all types of offenses that fall under a fine and penalty schedule, that is significant. We operate and do on-the-spot vehicle inspections, which often lead to vehicles being towed from the scene of where they are pulled over and dealt with by police or by law enforcement or whoever may be part of that targeted campaign on a vehicle. We have, as I say, coordinated resources between municipal government, their bylaw services, municipal police departments, our officers in the CVSE, and by working together with major agencies and institutions as well. We have had awareness campaigns and also led to getting vehicles out of service, out of operating in this illegal industry. YVR International Airport is one of those that has helped with the enforcement and education strategy that we have deployed. There are some other issues that we are working on with legal services, but requesting voluntary assistance from Google and Apple to remove these offshore illegal apps from being downloadable. And we'll continue to work on that and hope to get full compliance and cooperation from big tech firms like that have the platform that supports this illegal industry.
Member Kelowna West.
Mr. Speaker, just in terms of the rationale for looking at this is that clearly the minister agrees that these illegal operators are certainly the vehicles haven't maybe met the standards or inspection standards. The drivers may not have the necessary licensing. Certainly they're operating illegally. So the fine, he says, is $1,150. But he used a term earlier that said that growth and enforcement. And so am I to understand that growth and enforcement is through an extension of asking municipalities, by law, YVR, the ones that he just cited, or is there specifically targeted enforcement measures by PTB or the CV, the Commercial Vehicle Safety Inspection Branch?
Minister.
Thank you. So by coordinating between various agencies and levels of government and enforcing with our shared jurisdiction over this illegal industry, we've made it a priority. And we've learned a lot of things about how it operates, and so the enforcement gets more sophisticated as it goes. And so I think in answer to the member's question, it's through coordination, through dedicating resources towards cracking down on illegal ride-hailing, that we have seen a growth of enforcement.
Member.
Okay, thank you. to the minister. So I'm, Mr. Speaker, I just to clarify that then that means that there is no further hiring of people to enforce this. This is through the coordination as the minister has described and working with other partners on this. So I think I just want to kind of, he mentioned about the surge, if you want to call it, in temporary operating permits. That's one of the things that we're talking about here, and I'm just wondering if he could describe the size of the nature of the temporary operating permits and whether it's around demand, whether it's certain times of the year, in just terms of how many of these temporary operating permits or operators are out there that we're gathering under Bill 13 in terms of the enhanced safety precautions and checks that we, were being brought in today.
While the minister is thinking of his answer, welcome to the family up in the gallery. For those two young people, we're debating a little bill, which, if it becomes law, will change how transportation is conducted in our province. So on one side, you have the critic for transportation asking very hard questions of the minister, who's providing very good answers back to the critic. So thank you for coming and watching. Minister of Transportation and Infrastructure.
Thank you, Chair, and to the members. So I'll give a little bit of data on temporary operating permits issued. The last pre-pandemic sort of normal year we have, there were 42 temporary operating permits issued that increased the fleet size of taxi service. That dropped the following year when we were in the throes of the early stages of the pandemic to 5. It recovered somewhat, although not much, in 2021 to 14 being issued. Peak season is, and the need for temporary operating permits is again made by the Independent Passenger Transportation Board. They look at data, they look at the application on its merits and the estimated demand that they anticipate. So factors like the cruise ship season coming back this month would be one of the things that they would likely look at. The region and what sort of Christmas tourism looks like. So they determine what peak season and upticks in demand are going to look like and respond to the applicants for a temporary operating permit on that basis.
Member for Kelowna West.
Thanks very much, Mr. Speaker. So just to follow up on that, with Clause 1 of Bill 13, talks about, the temporary operating permit operators or the holder of those operators having to go through these. And I'm just wondering, based on the temporary review, how many of these temporary operating permit holders have gone through the record checks that are being brought into force here?
Minister.
Thank you, Chair. So the record checks that are described or referred to in this bill came into effect and became practice in about September 2019. So every temporary operating permit applied for since that date has had a criminal and driver record check. In fact, every driver in the industry since that date on a regular license or a TOP has undergone those background checks. And that's really the essence of this bill. We want to continue that. We've been doing it for close on 3 years now, and it's a good practice. It's one that the Legislative Committee recommended that was in the bill that we adopted in 2019, and one that we want to have made permanent should this bill be passed in this legislative sitting.
Member.
Thank you again, Mr. Speaker. And further on Clause 1, of the record check reviews, reviewing people that have been perhaps turned down, how many have been overturned, and for what reasons were they, what was the reason that they were overturned and been able to given temporary operating permit?
Minister.
Thank you, Chair, and thank you to the members. So I have some data around these appeals from 2019 to March 31st, 2022, so last week. 144 record review check appeals have been conducted, of which 51 were approved. 36 were denied, 35 were withdrawn, and there's 22 that are currently in processing, or there has been no decision rendered as of this date. The ones that are overturned and allow a person to become licensed are ones where the offense or whatever shows up on the record check and is flagged is an offense that's totally unrelated to the passenger safety objectives of the ministry and the operation of a passenger vehicle.
Member.
So thanks, Mr. Speaker. Again, on Clause 1, just to the Minister about the timeline. So if I'm an operator and I submit and I'm turned down by the PTB through this record check process and I have an appeal, how long does it normally take for that appeal to be heard and reviewed?
Minister.
Thank you, and to the members. So if somebody is deemed ineligible because they've committed an offense and the record check triggers that, and it sees that this person holds a commercial license of this nature, they have 30 days upon notification to apply to the Passenger Transportation Branch. They can do that by email, mail, or in person. So it's really in their hands in some cases in that early stage about how quickly they may wish to have reconsideration. So they could do it in one day if they wanted, but they have up to 30 days. And then I'm advised that typically once the documentation and the application is made, it takes approximately 1 to 2 months for a decision to be rendered. It does depend on how much volume they're considering and maybe the complexity and circumstances of the material they're reviewing, but that's normal business practice. So somewhere between 30 to 75 or 90 days is, I think, typical.
Shall Clause 1 as amended pass? So ordered. Shall Clause 2 pass? So ordered. Shall on Clause 3, Kelowna West.
So thanks, Mr. Speaker, through to the Minister, just in terms of the information about the appeal process. I just wondered, can the Minister provide an example of what would be considered uncertain, whether the person has a record that includes a prescribed matter?
Minister.
Thank you. And to the member, prescribed matter is defined and outlined and referred to in the Act and in the regulations. Some examples, assault charges, maybe accumulation of excessive speeding tickets that go against the regulations to hold this kind of a license. Those sorts of things are prescribed matter.
Member.
Thanks, Mr. Speaker. So just further on that particular matter, in the case of an individual, the person has a record that includes a prescribed matter, and the person believes that the matter is unrelated to the person's work or intended work as a driver. I guess just to be clear, is it laid out that the people that are applying for this would know exactly what are the prescribed matters? They can find that out easily and it's easy to identify?
Minister.
Thank you. And to the member, so when somebody is denied their license, they are directed to the Passenger Transportation Branch. We have the information about prescribed matters, and and are able to provide that. It's also available electronically on websites that the notification to the licensee who's lost their license is directed to.
Shall Clause 3 pass? Shall Clause 4 pass? So ordered on Clause 3. So ordered on Clause 4. And on Clause 5, Kelowna West.
So thank you, Mr. Speaker. Just in Clause 5, Section 59.4, I just want to clarify what kind of timelines are being considered.
Minister.
Thank you, and thank you to the members. So we're looking to retain the existing timelines of 30 days. It's possible we would extend it if drivers were struggling to meet those deadlines. These are gig economy workers. They have many occupations sometimes in their lives, and if that was an unreasonable timeline that was causing them stress and missing these deadlines, it gives us the flexibility in the future to change those timelines, and that could happen. We have, because of the pandemic, a TNS ground transportation industry that is a fraction of the size that we anticipated it would be because of the economic disruption, because of the health restrictions and regulations that came into effect, the number of people working from home, the member knows all the impacts. So we're going to see, I think in the future, as we continue to see the economic recovery, as we continue to see things come back like business and conventions and tourism travel and all sorts of things, including large events and things that are happening now. We'll be monitoring that going forward, and it gives us the flexibility to see whether those timelines are the right ones or whether they should be adjusted.
Kelowna West.
Thanks, Mr. Speaker. Just to the Minister, in Clause 5, the new section in 59.4, subsection B, paragraph E, and it talks about the notification requirements. I just want to clarify what the notification requirements are in this particular clause.
Minister.
Thank you. So there's two components to notification. One is to the taxi or TNS licensee and to the driver, the license holder, who had their license denied. So the notification is of the status or the outcome of the process, whether the decision has been overturned or upheld.
Thanks, Mr. Speaker. Just to be clear, so the notification it goes out. How is it delivered?
Minister.
Thank you. So it is the correspondence is done electronically unless there's a preference expressed for a hard copy in the mail.
Shall Clause 5 pass? So ordered. Shall Clause 6 pass? On Clause 6,
Just,
commencement.
Mr. Speaker, a quick question about, I guess, the fact that we know that the temporary measures end on September 16th, but why is it that this is coming in by regulation in terms of having the Lieutenant Governor and Council rather than just the date of September 17th?
Minister.
Thank you. Great question, challenging one, but I think I've got this clear now. So September 16th is a self-repealing date that's referenced in the current regulations. When this bill becomes law and subsequently we make regulations by order in council, that will create the permanency that we are seeking here with this amendment to the Passenger Transportation Act. So we have many calendar days of opportunities, weeks of opportunity to do that, you know, royal assent will be the next step, and then we'll follow from there. But that's really the short answer. Is that they're not really related. September 16th is the kind of drop dead date when the when this clause, this requirement would self-repeal itself.
Shall Clause 6 pass? So ordered. Shall the title pass? So ordered. Minister.
Chair, I move that the committee rise and report the bill complete with amendment.
Members have heard the question. All those in favor? Opposed? Carried.
Committee Chair.
Thank you, Honourable Speaker. Committee reports Bill 13 complete with amendment and seeks leave to sit again.
When shall the bill be considered as reported? Government House Leader. So ordered. Government House Leader.
Thank you. I now call continued debate on Bill 14.
Second reading?
Yes.
Second reading. Okay.
Committee of the whole.
Oh, committee. All right, Committee Chair.
We'll take a short recess while the appropriate parties assemble themselves here. Thank you. All right, members, let's call this committee back into order. Bill 14, Wildlife Amendment Act 2022 committee stage. And when we left off, we were on Clause 1. Shall Clause 1, does the member for Nechako Lakes is raising his hand. Member for Nechako Lakes on Clause 1.
Thank you, Honourable Chair, and I know the member from Saanich North of the Islands had some interest in having some questions just before we start moving too far into the clauses. And I'm not sure, of course, this is the disadvantage of being doing remote. I'm not sure if the member is in the chamber or coming into the chamber. So perhaps we can just canvass a couple other quick little things before we before I go on to questions on Clause 1 and give the member from Saanich North from the Islands a chance to get back in. I also know that the member from Vancouver Langara was interested in asking a few additional questions, but I don't think he's available this afternoon to carry on. So maybe I can start with this. You know, we canvassed a number of things yesterday associated with wildlife, with the changes on Bill 14. A number of opening questions to set the stage for the committee stage on Bill 14. And the crux, you know, as the minister has said, the crux of this bill is to utilize Indigenous knowledge to help with making changes or giving guidance to decision-makers on wildlife, and I'm assuming to make changes to the Wildlife Act as well, which is good. It's very appropriate. Certainly coupled with science-based information, it's important to be able to have that. It also enables the sheltering agreements, which provide an opportunity for reflection of what has happened historically on the land base with First Nations and neighboring First Nations. And of course, it deals with some confidentiality. We'll get into that. When the minister put this together and codified what we're looking at here on Bill 14, I'm curious about the intent. Is it just to codify what has been happening traditionally, or does let me take a step back. Yesterday, when we talked about these agreements, I asked the minister if there was any of these types of sheltering agreements. Of course, they weren't called that, but these are agreements between nations. If any of that was in written form in the past, the minister said there hadn't been. You know, I do know that there has been some of these, and some nations have talked to me about these historically as well, particularly up in the area that I represent, Nechako Lakes. But I'm wondering if the intent of Bill 14 is to simply codify what has been happening traditionally, and quite frankly, what's allowed under case law that has happened historically, or whether it is actually to expand opportunities. And does the minister see this bill and the introduction of this bill as being a potential to expand opportunities for First Nations to be able to consider things like a sheltering agreement?
If I might, member, sheltering agreements are under Clause 3. If the member wanted to ask about sheltering agreements, it might be more appropriate under the particular clause.
Thank you, Honourable Chair, for that direction. The intent of my question and the intent of why I asked this question is to understand the reason for bringing this bill in as opposed to the agreement itself, which is why I placed this question up front before we get into Section 3 or Clause 3. I'm trying to understand what the clerk has tried to put in place in terms of this, and what the clerk is or what the minister is considering, how the minister considers that this act will be used, and whether or not there is some other meaning behind it that may not be transparent directly in what was written in the bill. So with your indulgence, I would ask the minister if she had an opportunity to be able to answer that question.
If I might, sheltering agreements are the entirety of Clause 3, to my understanding, so with a slight addition around authorization. So again, I think it would be more appropriate to ask about sheltering agreements, how they came about, where they're from, that kind of thing, under the specific clause that actually relates to them. We are on Clause 1.
Thank you, Honourable Chair. Actually, we aren't even quite even on Clause 1. As we ended yesterday, we were talking about the information that was put forward that brought forward this bill, the engagement. We were talking about engagement with various organizations, whether that was the First Nations, in the minister's term, if I may look at which he has called Forum, which is the BC Wildlife Engagement with First Nations, intensive papers. There's a whole number of things that went into the creation of this bill to put forward this bill to bring it to the floor. And one of the things that I'm looking at, maybe I won't call it a shelter agreement then, because then it will avoid talking about section or that 3s. So let me phrase it this way then, if I may, Honourable Chair, through to the Minister. Historically, First Nations have had agreements that have allowed people to come into their territory, other nations to come into their territory for harvesting purposes. Usually that's a reciprocal type agreement between nations, as we discussed yesterday on this. Those opportunities to be able to do that type of arrangement is something, of course, that has gone on throughout time. It's something I believe the courts have talked about, and my question to the Minister is the intent of drafting Bill 14 to expand those opportunities?
Minister.
Just again to reiterate who I've got here with me today, I've got my Deputy Minister, Rick Manwaring, my Assistant Deputy Minister, David Muter, Yemi Sanuga is our Director of Legislation, and Jennifer Salakis is our Executive Director responsible for wildlife. The intent of the bill, as I said yesterday for the member, is to add a provision regarding the obligation of decision makers under the Act to consider relevant Indigenous knowledge, to add provisions governing the confidentiality of Indigenous knowledge, and add a provision authorizing the minister responsible for the Act to enter into agreements with First Nations or groups of First Nations in BC regarding sheltering, a traditional practice whereby a host First Nation permits members of another First Nation to harvest wildlife within the host treaty harvest area or traditional territory. And I'd be happy to get into further detail on sheltering agreements when we get to Clause 3.
Member.
Thank you, Honourable Chair. Perhaps then I could ask the question this way of the Minister. Is there anything in the court, in the legal world, through precedents that has been laid out in court cases that would prevent First Nations from being able to do what the intent of this bill is already? And to that extent, if there is, then that's interesting. If there isn't, then I'm asking the purpose of actually bringing this bill in if First Nations already have the ability to be able to do this.
Minister.
Chair, and through you to the member, again, the question is directly related to Clause 3, and I'd be happy to discuss those issues further when we get to Clause 3.
Member.
Thank you, Honourable Chair, and I want to thank the Minister for taking 3 minutes to tell me that she wasn't going to answer the question. Always appreciated. Honourable Chair, when we talk about Section 1, I just want to do a quick review of a little bit of the frustration that you may hear in my voice, and I apologize to the Chair for that, as I have great respect for the Legislature and for the Chair, the authority of the Chair, and for the workings of government. But I find it curious in the whole line of questionings that we've had between yesterday and this morning, or yesterday and the first few here this afternoon, specifically about questions Minister either didn't answer, or, for example, in the question that my colleague from the member from Vancouver-Langara asked, which was directly around the implementation of UNDRIP and the great fanfare that came forward in terms of that plan, which was brought in a couple of weeks ago. It was an opportunity for the minister to tout how this bill fit in as part of that, and for whatever reason she refused to talk or answer about that. I find it curious in that this bill being brought forward and desired by First Nations wouldn't be something that the minister would have wanted to expand on, and which is troublesome because there are many questions that yet to be had associated with the clauses in this act, and my hope is that we'll actually get to be able to understand the intent of what the minister and the government is trying to do with this act without having to go through the rigmarole of asking the question half a dozen times to try to decipher what the meanings are. So perhaps I'll start, Honourable Chair, with a question which is a little more straightforward and easy for the minister to answer. With regards to Section 1, where the definition of Section 1, I'm reading this in for the record, First Nation means a nation whose traditional territory includes land within the boundaries of British Columbia. I understand the 204 nations, give or take, that are in British Columbia, that are hosted in British Columbia. I'm wondering if the minister can provide the House with a list of any other nations who are not part of that 204 list that may have an interest in British Columbia.
Minister.
Thank you, Chair. So as the Clause 1 states, this refers to the 204 First Nations whose traditional territory includes the lands that are in the traditional boundaries of British Columbia.
Member.
Thank you, Honorable Chair. That's curious in terms of the answer. And perhaps we just need to frame up here a little bit for the affirmative discussion. Historically, when Europeans first came in here, when Canada was going through the process of forming a country, and British Columbia, of course, was created, there was a process that the federal government went through, which created the nations that we have today. And they would go through community by community and create these nations from this. But prior to that happening, that wasn't necessarily the case. There is, as the minister I'm sure aware, I think it's 32 different languages and 64 dialects roughly in British Columbia. And many of these groups, many of these bands that we call nations today, of course, were part of a single group or identified with a single group. You know, for example, the Wet'suwet'en people, which has 6 bands, but is considered the Wet'suwet'en people. Same with the Carrier or the Sokoteen or these types of things. And of course, with the creation of all of these individual bands across the province, eventually that led to claims of territory. And that territory, of course, extended out, and there's a process that I'll get into a little bit more detail in my next question associated with that. But so that through that process, we now have these nations created. And so specifically around this, whereas, like I say, there's the 204 nations that are within British Columbia that we identify today through this process, the colonial process that created these nations some 100 and plus years ago. There are nations, of course, whose territory has gone into British Columbia historically. And in particular, I'd like to ask the minister about the Syilx Nation, which there was a specific court case that happened a number of years ago, where an individual, and perhaps I should just take a moment back for people to understand, this was a nation that was in British Columbia, but back, I believe, in the 1950s, maybe it was early 60s, I can't remember, the last living member of the nation in British Columbia passed away or moved away. And there were no other members of that nation within British Columbia, and so the federal government declared the nation extinct and no longer a nation within British Columbia. However, the people live just south of the border and have identified, of course, and being very well connected historically with the Okanagan Alliance. They still have a claim into British Columbia in terms of their territory that is part of their influence. The Okanagan Alliance, of course, still considers them part of the Okanagan Alliance and the Okanagan Alliance nations. And so when the definition here is a First Nation means a First Nations whose traditional territory includes land within the boundaries of British Columbia, I'd ask the minister if she could provide some clarity about whether or not there has to be a group of individuals that identify with the nation that live within British Columbia and are identified in terms of a community, or whether or not a band like the Syilx Nation now would still have a claim in British Columbia and would fall under the definition of First Nation under Clause 1.
Minister.
Thank you, Chair. And, excuse me, case law regarding Aboriginal rights recognized and affirmed by Section 35 of the Constitution Act of 1982 is constantly evolving. Courts have imposed a site-specific requirement on Aboriginal harvesting rights, meaning that these rights may only be exercised on the land traditionally used for the activity. At this time, only First Nation groups in British Columbia with established rights would have Section 35 rights to hunt, trap, and fish.
Member.
Thank you, Honourable Chair. And I seem to recall that court case actually broke ground on that case, the case of the Silex. And I'm sure I'm mispronouncing that name, but I will continue to use that pronunciation. In that, the person who hunted in there was actually hunting in their traditional territory, which overlapped, of course, with other Okanagan Alliance nations, as well as with the Tanaha, and harvested an animal. They were caught by the conservation officer and was charged. The case was dismissed as the court. My understanding of that court ruling was that individual had the right to be able to hunt within his traditional territory, even though that individual was from the United States. And so I'm curious if just from what the minister has responded, the minister seems to be saying that that individual does not have a right to hunt, or perhaps I'm misinterpreting what the minister is saying. And maybe the minister is saying that that nation doesn't exist in British Columbia and would not be considered a First Nation under Section 1. So perhaps if the minister could just provide some clarity on that.
Minister.
Thank you, Chair. So under this bill, the Sinaik member that the member refers to would be dealt with under Clause 3 in the context of Clause 3, and we can address that when we get to Clause 3.
Member.
Thank you, Honourable Chair, and I think the Minister missed the point of the question. The questions are on the definition of a First Nation. According to the definition of a First Nation, it says means of First Nations whose traditional territory includes land within British Columbia, within the boundaries of British Columbia. There is no requirement in that definition that I can read that says a First Nation is required to have a community or people living within British Columbia. It only says that it needs to include land within the boundaries of British Columbia. So perhaps does this need an amendment, or how does the minister be able to say that a nation such as the Snakes, if that's how it's pronounced, would not qualify as a First Nation in British Columbia, even though they have traditional territory that is included within the boundary of British Columbia?
Thank you, Chair. So the definition, the First Nation, means a First Nation whose traditional territory includes land within the boundaries of British Columbia. What the member is referring to is a relationship between nations, and that is part of Clause 3, which we can canvass and answer in Clause 3.
Member.
Thank you, Honourable Chair. And once again, the Minister is not answering the question. In the court case, it was very clearly stated that there was traditional territory of the nation within the boundary of British Columbia. And just because there was no longer people living within British Columbia, they considered that to still be part of their traditional territory, and it was talked about. So it is perhaps, I'll put it this way to the Minister. Is the Minister saying that the statement of fact that there was traditional territory of a nation within British Columbia is not valid in terms of this act? Is the Minister saying that a nation, a traditional territory of a nation must be of a nation that exists within British Columbia where there is a occupied community or people living within the British Columbia? I mean, this is an important point. I mean, there's some other factors, there's some other issues that need to be thought about in terms of this. In terms of overlap and the extension of claims. And so there's a number of situations like this. But I'm trying to understand, because right now, the way I read this, a First Nation word says means a First Nation. Well, first of all, it defines First Nation meaning a First Nation, but that's a different point, whose traditional territory includes land within the boundaries of British Columbia. And so in this particular case, is the Minister saying because the nation no longer exists in Canada, was extinct in Canada, is in the United States, that is because they don't have people living in British Columbia, or it's no longer recognized by Canada, it's no longer considered a First Nation?
Minister.
Thank you, Chair. And again, through you to the member, the definition of First Nation means a First Nation whose traditional territory includes land within the boundaries of British Columbia in Clause 1. The case law with respects to land-based rights are constantly evolving, and we consider the example the member is referring to in the development of Clause 3, and I'm well aware of the example the member is referring to because it actually took place in my constituency.
Member.
Well, thank you, Honourable Chair. And after waiting close to 10 minutes to get an answer that was a non-answer once again, and I apologize for pointing that out, but I asked a simple question, whether or not, I guess some more context is required, Honourable Chair. The intent of my understanding of UNDRIP and the process that First Nations want to go through is to decolonialize, to move away from the colonial systems that's been imposed upon governments, upon First Nations. When you think about the boundaries and where nations lived in their traditional territory, I mean, we have these artificial lines, whether it's the line between two different countries or the line between two different provinces or territories. We put these lines on the map, but their territories aren't necessarily follow those lines. Maybe they do in some cases, but in most cases they don't, because these are straight lines, like, for example, down latitudes and longitudes. And so there is a nation, and the minister is well aware of this case, that exists in the United States, that used to exist in Canada, that has traditional territory within British Columbia. I am simply asking the question, if that nation is not considered a First Nation under this Act, even though they have traditional territory that extends into British Columbia.
Minister.
Thank you, Chair. Welcome to the Chair. For the members, in direct answer to his question, no one is avoiding his questions. I'm certainly not avoiding his questions. I am just simply explaining to the member that the example the member is referring to is better canvassed under Clause 3 of this Act.
Before the member Kelowna Mission.
Honourable Speaker, I seek leave to make an introduction.
Shall leave be granted?
Aye.
So ordered.
Thank you so much, Honourable Speaker. I rise today to make a special introduction. There's a very special guest here today, and she's joined us from my hometown and riding of Kelowna Mission. Her name is Helene Letnick. She's an extraordinary woman, a mother and a grandmother of almost 3, a wife and an artist. And if anyone wants to see her artistry, please come to my office. You are welcome to see the beautiful painting that hangs behind my desk of the Okanagan. And I actually went to Helene and said, I need something from the Okanagan that reminds me of home for my office. And there's no better artist because I have many of her paintings actually in my home as well. I've known Helene for almost as long as I've known her husband, the chair today. And when I asked the member from Kelowna Lake Country and our chair today how he would describe Helene, he responded by saying simply, and I quote, "She's my home, my best friend, and my soulmate." Would the House please join me in welcoming Helene here today? Thank you.
Okay, member in the Chaco Lakes, can you top that?
No, I can't, but I really appreciate, Honourable Chair, the offer for me to do that. I might be able to in terms of talking about my own special lady, that my lifelong partner, but that is would be a serious deviation from discussing Bill 14 in clause or section 1. So I asked the minister a direct question. She didn't answer once again. Why she's being elusive or evasive on this, I don't know. The simple question, and maybe I'll just put it in as few words as I possibly can so I can give her as much time as she wants to formulate her answer. Is the nation in question, I call Silex the Snikes, is that considered a First Nation under this act? And if it is not, even though it has traditional territory within British Columbia, why is it not considered a First Nation under this act?
Committee will recess for 10 minutes. Calling the Committee on Bill 14 back to order. Minister of Forests.
Thank you very much, Mr. Speaker, and just I wanted to confirm, make sure that I was stating this accurately, and I've been received legal advice that on the question of whether the Sinique are a nation in BC for the purpose of this bill, it hasn't been determined by the courts. The court case only determined that the individual had hunting rights, but not whether they had land rights as determined by this bill.
Member for the Chaco Lakes on Clause 1.
Thank you, Honourable Chair, and I thank the Minister for that. And what gave the individual the rights for hunting was the fact that it was their traditional territory. And the ambiguity of the definition of First Nation in this act leads to the question that will go to courts. And so is it the minister's intention to leave this blank and allow the courts to define what First Nation is, or would the minister prefer that this legislature define what the meaning of First Nation is?
Minister.
Thank you, Chair. I believe the definition defines what a First Nation is when it comes to this bill.
Member.
Thank you, Honourable Chair, and I anticipated that would be the minister's response. And let me read it once again into the record. Means a First Nation whose traditional territory includes land within the boundaries of British Columbia. I'm going to come back to this particular nation in terms of the question, but I'm going to ask it through other similar issues, because the case that we are talking about is a case of a nation that used to exist in British Columbia, that had a defined traditional territory within British Columbia, but was considered extinct because the last person either passed away or moved into the United States. But that does leave it with a question of an Indigenous group or Indigenous body, which we in this province call First Nations, that is down in the States, that has a connection to British Columbia because of its traditional territory. Traditional, of course, meaning historic territory, unless the minister is talking about current territory. So let me then ask a question around First Nations. There are many neighboring nations, whether they are in the Yukon or the territories or Alberta or Alaska, whose traditional territories, long before we came around and created this province of British Columbia, have extended into British Columbia. And in fact, I have had meetings with many First Nations, or a number of First Nations from the Yukon, who are asking to revive mining projects or to receive benefit agreements because their traditional territories go down and extend into British Columbia as part of that. So I'll ask the minister, the question is, do any nations that reside within Canada, particularly in the Yukon, whose traditional territories come down into British Columbia and are recognized in British Columbia, as a matter of fact, they have a strength of claim associated with those territories in British Columbia, which is used by the Attorney General's office for when we're moving forward projects. Are any of those nations considered First Nations under this act?
Minister.
Thank you, Chair, and that would best be canvassed under Clause 3.
Member. Sorry, Honourable Chair, and that is actually quite, once again, a very evasive and quite frankly, I find offending response by this minister. I am asking about the definition of a First Nation. Clause 3 is about a sheltering act. I do not understand why the minister would not be able to provide an answer associated with the definition of a First Nation, which is Clause 1. And the question is, there are nations in the Yukon which have territory, and I will read this again. It means a First Nation with a traditional territory includes land within the boundaries of British Columbia. these nations have traditional territory that extends into British Columbia. Are they considered a First Nation under this act? And if they are not, why would they not be considered a First Nation given the definition as it's written?
Minister.
Thank you, Chair. It does not exclude First Nations whose boundaries may be only partly within the borders of BC.
Member.
Okay, that's an interesting way of saying it. I was looking for a yes or no. So if it doesn't exclude First Nations whose territories go into British Columbia, then the minister said earlier that it only included the 204 nations within British Columbia. Could the minister please clarify which answer is correct?
Minister.
Quick answer is the answer is yes. It recognizes the 204 nations that, the 204 recognized nations that we have a duty to consult with, which also includes some nations which are in the Yukon and Northwest Territories, which is the definition that we have put forth in the bill. First Nations means the First Nations whose traditional territory includes land within the boundaries of British Columbia.
Member.
Thank you, Honourable Chair, and I wonder if we should bother going back and answer the question I originally asked the Minister associated with the definition of a First Nation was how many nations were outside of British Columbia, outside of the 204 nations that reside in British Columbia, that have communities live in British Columbia, are considered to be First Nations under this Act. I believe that was roughly the question I asked. The Minister responded by saying that it was just the 204 First Nations within British Columbia that are considered First Nations. So maybe I will re-ask my original question to the Minister. Can the Minister provide a list of nations that are not part of the 204 that reside within British Columbia, that have traditional territories that go within British Columbia, that would be potentially considered a First Nation under Bill 14?
Minister.
Yes, we'll get the member a list.
Member.
Thank you, Honourable Chair. And it's unfortunate we've spent an hour to answer the first question that I had in terms of going around through all of this. But c'est la vie. We have until June to finish this bill, so we will find our way through it as we go. So I want to move on to another question around the definition of a First Nation and recognizing in British Columbia, and that is to the historic Treaty of Treaty 8. There are a number of nations associated with Treaty 8, some residing outside of British Columbia, but they have rights for hunting within the territory of Treaty 8 as they have adhered to Treaty 8. Does the definition of First Nation include a Treaty 8 nations which may not reside within British Columbia?
Minister.
Thank you, Chair. So the nations of Treaty 8 who have traditional territory within BC are part of the 204 nations.
Member.
Thank you, Honourable Chair. When Site C was under consideration for construction and the disturbance of Site C in the Treaty 8 territory, there were nations who did not reside within British Columbia. In other words, they did not have communities within British Columbia that were consulted because of the impact to their traditional territory and to their Treaty 8 rights. And so I'm just wondering, similar to the situation we have in the Yukon, whether the Minister would care to have another look at that to determine whether or not there are any Treaty 8 nations other than the ones that have communities within British Columbia that may be considered a First Nation under this Act.
Minister.
Thank you, Chair. And I don't understand how that's relevant to this bill, so could the member please explain so we have an answer?
Sure.
Member.
Thank you, Honourable Chair. Well, it's clear under Section 1 of this Act, it says, or Clause 1 of this Act, it says First Nation means a First Nations whose traditional territory includes land within the boundaries of British Columbia. Clearly, when there was a impact of resource development in the northeast of the province, there were First Nations that did not reside within British Columbia that were consulted and accommodations offered for impact on their territory and their rights. And so I'm curious, just as it was with the nations in the Yukon, or potentially nations in the in Northwest Territories, whether or not any of those Treaty 8 nations are considered to be First Nations within the Act that don't have communities within British Columbia.
Minister.
Thank you, Chair. So the consultation on Site C was for specifics of that project. Today it's about adding a provision regarding the obligation of decision makers under the Act to consider relevant Indigenous knowledge, to add provisions governing the confidentiality of Indigenous knowledge, and add a provision authorizing the minister responsible for the Act to enter into agreements with First Nations or groups of First Nations in BC regarding sheltering, a traditional practice whereby a host First Nation permits members of another First Nation to harvest wildlife within the host treaty harvest area or traditional territory. So I don't feel that what the member's asking is actually relative to what we're trying to put forward here in this bill.
Member.
Thank you, Honourable Chair, and I see the pattern continues. So we'll take an hour carrying on with this until we get to the core of the answer. The question, Honourable Chair, and the reason for this question is really quite simple. Under Clause 1, it says, under definition, First Nation means a First Nation whose traditional territory includes land within the boundaries of British Columbia. This is relevant simply because that it is used as the foundation for other sections in this Act in terms of what a nation is able to do, present, or be involved in as part of this Act. It is very important to get a very clear understanding of what the definition of a First Nation is. And it's been clear in the time that we have spent here that the minister has not been able to provide a clear definition. In the first case, she came out and said that nations outside of British Columbia were not included. It was just the 204 within. After an hour of going back and forth and debate, she has conceded that there are nations outside of British Columbia that are included. My understanding of this and the need for asking these questions, particularly around Treaty 8 nations, is because they have a claim within British Columbia, a potential claim of territory within British Columbia. We will get to those questions as well in a bit. But the importance here is very clear. If there is going to be a nation that is going to create an agreement that has traditional territory that is defined as a nation within British Columbia, it's important that all people in British Columbia, First Nation and non-First Nation, understand the ramifications of the definition of First Nation, which is why I'm spending so much time on this particular clause. So, for example, I'm asked about the nation across the states that we spent a great deal of time talking about because I wanted to be able to understand whether it was considered a First Nation within British Columbia. If it was, then it would actually have the ability to actually have a hosting agreement, to actually be able to be a host First Nation. And if it's not, then it wouldn't have that ability. But the only way to know that is to know whether it is by definition of Clause 1, which is a First Nation. We now understand that there are nations within the Yukon and potentially other jurisdictions within Canada that do have a claim within British Columbia and are considered a nation under this within British Columbia, which then would give them the right, according to this Act, to be able to participate in the clauses in the future, other clauses that we're yet to debate within this Act. So it's very important to get a clear understanding from the minister, and which is why I keep insisting what nations are included and what aren't. And earlier, the minister said she would provide me a list of those nations from up in the Yukon. But it does lead me to wonder whether or not the minister had even considered this and the fact that she wouldn't have a list like that available right away to be able to provide to this House so that there would be clarity so that people, Indigenous, non-Indigenous across this province would understand the intention of what the minister is trying to do with Bill 14. So I'll ask again, and it doesn't have to be in the context of Treaty 8, and it certainly doesn't have to be in the context of Site C. I only use Site C as an example of why nations were included. But Treaty 8, my understanding of the historic Treaty 8 is that nations who have adhered to Treaty 8 have rights within the boundaries of Treaty 8, which includes British Columbia. And those rights include hunting and gathering, and in terms of their traditional ways of life. So this is why I'm asking whether or not nations within Treaty 8 are considered to be a First Nation under this Act. If they aren't considered to be a First Nation under this Act, the minister can simply just say that, and that would clarify it, and we'd be able to move on. We wouldn't have to go through this long rigmarole and process. But the minister doesn't seem to want to be clear in terms of these questions. So the two questions I have is, does the minister have the list of those nations up front? Has she actually talked to the nations within British Columbia and those outside of British Columbia about this act that it would be considered First Nations in terms of those up in the Yukon, and or any of the other Treaty 8 nations outside of the 6 or 7, whichever it is that is in British Columbia, that are considered to be a First Nation under this act?
Minister.
Thank you, Chair. And I understand I have been fairly clear with the answer. The member maybe has trouble understanding. The answer is yes. If a First Nation has a treaty right or traditional territory in British Columbia, then we would consider them a First Nation under the Act, an Act that was co-developed with First Nations from BC, an Act that First Nations agreed to the definitions of, an Act that the First Nations were very involved in. So yes, if a First Nation has a treaty right or a traditional territory recognized in BC, then we would consider them a First Nation under the Act.
The Chaco Lakes.
Thank you, Honourable Chair. That was the first time in almost 2 years that I've actually heard a very straightforward and clear answer to a very complex question. And it took quite a while to get here, and it certainly does not line up with what the minister said originally. And so if the minister is wondering why I have trouble understanding her answers, maybe she should go back and look at answer, because what she has been saying all along is not what she just said. And if she had started with that, we would have saved ourselves a whole bunch of time and grief. And so that's an interesting answer, and I really do appreciate the minister being very clear on that. So nations outside of British Columbia are considered nations if they have a traditional territory claim, which brings me back to the case of the nation across the American border, whether it is over into Alaska, as there are nations within Alaska, which, according to the Environmental Assessment Act, have the ability to be able to participate in environmental assessments in British Columbia, or in the particular case that we spent a great deal of time talking about with the Snakes First Nation associated with the Okanagan Alliance. And so perhaps with the new definition that the minister has just provided, could she provide me an update as to whether or not any nation which resides outside of Canada, which has a claim of territory within British Columbia, would be considered a First Nation under this act?
Minister.
Just to be clear, the answer is if a First Nation has a treaty right or traditional territory in BC, then we would consider them in this act.
Member.
So, sorry, Honourable Chair, I just need to ask, because we spent a great deal of time talking about this act, about that particular nation. Does that include the Snakes people that are south of the border, south of the Okanagan Alliance into the United States?
I believe I've already answered that.
Chaco Lakes.
Thank you, Honourable Chair. And if you want to take a 10-minute recess, I can pull up all the answers and go, look, the answer has not been answered. The question's not. Matter of fact, the minister went out and conferred with the Attorney General and came back and talked about the changing case law, but did not answer a yes or no whether or not that nation has been included. It's a simple question. If it's been answered before, it would only take you a couple of seconds to answer. To the minister, is that nation considered a First Nation under this act?
Just for clarity, the Chaco Lakes, are you asking for a recess?
No, I'm not, because Hansard would not have the information available. So my apologies, Mr. Speaker.
Okay, thank you. Minister.
Thank you, Chair. As I said, in the case of the Senike, the court had no findings with respect to the Senike in the context of land in BC.
Member.
You know, all I'm asking for is Minister just to say yes or no. She seems to understand it very clearly. Can she just answer yes or no, please? Thank you, Honourable Chair.
The minister is asking to what question? The Chaco Lakes.
Thank you, Honourable Chair. I just asked for a question whether or not that particular nation is considered a First Nation under this Act. It's a simple yes or no question.
Minister.
Thank you, Chair. As I said, case law regarding Aboriginal rights, recognized and affirmed by Section 35 of the Constitution Act, is constantly evolving. As I also said, the court had no findings with respect to the Senike in the context of land in British Columbia.
Member.
All right, so where we're at, just to summarize this for you, Mr. Chair, is that regarding a nation that exists across the border into the United States, the minister is not saying yes or no. In other words, it will be an empty vessel law that will ultimately be filled by the court once it's challenged, because the minister is refusing to have a definition one way or the other. I suppose whether the minister had a definition one way or the other could still be open to challenge and defined by the courts, but it is unfortunate that we're not in a situation, and the courts do not have guidance from this legislature in terms of what the intent of the definition of a First Nation is associated with a nation that may have a claim from outside of British Columbia to British Columbia. And that's very unfortunate, but you know, we have canvassed that and the minister refuses to answer, so that is just fine. Well, it's not fine, but it is what it is. So, Honourable Chair, part of the process of defining a First Nation, you know, we have canvassed through, but I think the key piece in here, under the definition, under Clause 1 of First Nation, is traditional territory. So perhaps let's start off with a straightforward question, which I understand will not have a straightforward answer, and that is, how is the traditional territory defined within a particular nation within British Columbia?
Minister.
Thank you, Chair. And we're just, trying to get to the nub of what the member is asking. And I really would like him to define what he is referring to, because there's no definition of traditional territory, I believe, in any legislation, because it's constantly evolving in the law. And so if there's something that he has a better understanding of, maybe he could let us know.
The Chaco Lakes.
Thank you, Honourable Chair. Well, this is to use the language the minister used, the nub of the issue, traditional territory. Under this, First Nations means a First Nation whose traditional territory includes land within the boundaries of British Columbia. How is that land defined within the traditional territory?
Minister.
Thank you, Chair. Welcome to the Chair. The term traditional territory is a commonly used term in case law and in day-to-day usage.
Member.
Thank you, Honourable Chair, and thank the Minister for the vocabulary lesson on traditional territory. I was asking specifically about how the land is defined within a traditional territory.
Minister.
Thank you, Chair. And if the member could clarify, if the member is actually referring to overlapping, well, the member can roll his eyes, but I have staff here that are trying to understand what the member's asking as well. So, I would appreciate some consideration for the staff that are here. And if the member is actually referring to overlapping territories, we get into that and when it can be canvassed in Section 3 of the Act.
Member.
Thank you, Honourable Chair. And I know the Minister would like to rush through this bill and just tuck it all away and not answer questions. And I get that's what the Minister wants to do. And I suppose she doesn't want to defend this Act in terms of why she's brought it in the meetings in here. But the reality is we are on Clause 1, the definition of a First Nation. A First Nation means a traditional territory includes land within British Columbia. There is a process that is undertaken by First Nations and the province, which isn't always an agreement, and the federal government is involved, which defines land, the area of which would be considered as part of traditional territory of a First Nation. What I'm trying to understand from this minister is what she has used and what she is considering using with regards to land that would ultimately define whether or not a First Nation is within British Columbia. So, for example, we spent a great deal of time talking about First Nations that are outside of British Columbia, who have a traditional territory that comes within British Columbia, a traditional territory that is set up somehow, some way defined of the land that is within British Columbia. So I'm trying to understand from the minister what the process is that is being used by this government, and certainly as in reference to Bill 14, that would define the land within British Columbia that comprises a traditional territory of any given nation.
Minister.
Thank you, Chair. And BC has been engaged with First Nations for many years and has developed an understanding of the traditional territories that they each identify. Areas that we consult with them and engage in them in other other agreement negotiations as well. I mean, this is a long-standing tradition in this province.
Member.
Thank you, Honourable Chair. And I appreciate the minister's response with that. I'll quote, former chief from the Burns Lake Band, who was told that it's, their traditional territory was traditionally where they walked or where they wandered about. There is, other nations that have fought for territory and have a much clearer definition of where their traditional territory may be. There are some nations that, quite frankly, through the BC Treaty process, have expanded their boundaries for the purpose of trying to claim additional territory, even though it was not their original territory, so that they can receive benefits and potentially better settlements through agreements. And so how a traditional territory is defined, it makes up a very significant component of this bill. In particular, I mean, we're talking about a First Nation, and we're talking about First Nation, the definition of First Nation within British Columbia. And so obviously, this could impact potentially nations outside of the province that have a claim within British Columbia. It certainly wouldn't change the definition of a First Nation within British Columbia, although it does lead into questions further on down in the Act in terms of the traditional territory, as the minister has pointed out, which we will get to when the time comes. But I'm trying to understand whether or not this definition of traditional territory, which, not definition, but the inclusion of the words traditional territory as part of the definition of a First Nation, is if there is, a strength of claim associated with it, if it is just, what is put forth by a nation, whether there's any other information that's required to be part of it, so that whether a nation can or cannot be included within the boundaries of British Columbia and within the definition of a First Nation.
Minister.
Thank you, Chair. So the nations identify to us the areas in which they occupy and for the exercise of their rights. This is represented in a consultative area database and reflected in statement of intent in the treaty process. Consultative area database contains information provided to us by the First Nations, for example, traditional use studies, elders representations, and archaeology information.
Member. I believe you need to unmute.
Sorry, I was on mute, a common phrase coming out of COVID, no doubt. And thank you, Honourable Chair, and thank the Minister for that answer. And so just to be clear, the question around this is there a verification process that the province would use to determine whether or not there is traditional boundaries within British Columbia and that they would be considered as part of First Nation, or is it something that is put forward as a statement of claim, through treaty or other processes, and then just accepted by the province?
Minister.
Thank you, Chair. So the nations identify to us the areas in which they occupy and for the exercise of their rights. And as I said, this is represented in a consultative area database and reflected in statement of intent in the treaty process. The member might not wish to hear this, but he is really straying into, well, not straying, he is asking questions that would better be canvassed directly under Clause 3, which I have said a number of times, and I don't know why the member has such apprehension about moving forward on this bill when obviously what he's asking is in direct reference to the Clause 3 under the agreements in Clause 3, which would much better be able to answer rather than cherry picking under Section 1, which is this is definitely in Clause 3. And in no way, shape, do I want to rush through a bill. I want to make sure that everybody understands this bill. This bill was co-developed by Indigenous nations and very much appreciate the work that was done with them and that they agreed to the definitions that we are discussing. So I feel that the member would be far better served to have his questions answered in direct relation to Clause 3, which might be able to understand better what we're trying to achieve here.
Member.
Thank you, Honourable Chair, and I appreciate the Minister's comments. And as I have said before, and I will, it's worthy of repeating, I'm stressing this issue about the definition of First Nation because it talks about the land whose traditional territory includes land within the boundaries of British Columbia. And having had the experience I have had, I do know that there are claims put forward which may or may not be able to be backed up through evidence, but they are accepted as claims. It's a process that has gone through the treaty process. Those processes go through, and it's used for many other purposes. But the point of asking the question is, once again, it comes to nations that are outside of British Columbia. And I'll just use, for example, whether it be the Métis, that may claim, and they're obviously within British Columbia people, but they may claim a territory, for example, around Kelly Lake. They've made a claim. They've said that, you know, that's part of their territory. It's disputed by other First Nations, but there is a claim that that is within that area by the Métis Nation. And there are other nations which have claims within British Columbia, whether it's along the boundaries with Alberta or otherwise, that nations within British Columbia may dispute and say, no, they don't. But they have a claim, and they've put a claim in, and that may or may not be accepted by the province. And so what I'm trying to understand from the minister is the process at which the claim of land within the British Columbia boundaries is determined or verified, so that we can determine whether or not nations are within British Columbia and considered as part of British Columbia for the purposes of Bill 14.
Minister.
Thank you, Chair. So we accept the assessments of First Nations combined with research and analysis on these claims.
Member.
Thank you, Honourable Chair. Appreciate that clarification from the minister. So then maybe a more direct question, and this one should be fairly straightforward to answer, but I just want to make sure it's clear for me so that I know when I'm talking about this bill, you know, I've got it clear in my mind. Does the Métis Nation, the Métis people in British Columbia, through one of its organizations, which have a claim of territory within the, like I say, within the Kelly Lake area, potentially other areas, I don't know, are they considered a First Nation under this act?
Minister.
No, it's not a Métis or not a First Nation. Based on existing jurisprudence, in BC does not recognize Métis having land-based rights in British Columbia.
Member.
Thank you, Honourable Chair, and thank the Minister for that answer. If I may ask for a brief recess, 3 minutes or so, before we proceed to any other questions.
All right, we will take a brief recess. Thank you, members. All right, members, I'd like to draw the committee back into session. Bill 14, Wildlife Amendment Act 2022, currently on Clause 1. Member for Nechako Lakes.
Thank you, Honorable Chair. I have no further questions on Clause 1.
Shall Clause 1 pass? Aye. So ordered. On Clause 2, member for Nechako Lakes on Clause 2.
Thank you, Honorable Chair. Clause 2 talks about governing body in relation to First Nation means the governing entity of the First Nation, however organized, established by members of the First Nation. This question of governing body has been canvassed extensively in a number of whether it's estimates or other bills in the legislature, and it's an interesting question because First Nations organize differently, and components within First Nations organize differently, and so. I think it's important that we get a clear understanding from the minister in terms of governing body, in terms of its definition within this Bill 14. There's the bodies we understand or know, which we've talked about clearly, which is whether it's elected or whether it's hereditary systems. There are other governing bodies. There are sub-bodies within nations, whether it be clans, or whether it be in the case of the Nakazli Wuten Kehos. And so I'm wondering if to start off with, the minister could provide some guidance to me and to the legislature with respect to some examples of governing bodies that the minister would consider under this act.
Minister.
Thank you, Chair. So the definition of the governing body is at the discretion of the First Nation, and that would be recognized and accepted as they wish.
Member.
Thank you, Honourable Chair. I asked for some examples, but perhaps the minister is not interested in providing some examples, and I could potentially understand that, as they may not be an extensive list, and she may leave something out. The real challenge, I think, that there will be within this definition of a governing body is where there may be a dispute within a First Nation. Where there is a case, it's been well documented in terms of the wetsuit between the elected and the hereditary system, and even within the hereditary system, there has been dispute within the nation. And so, how will the government determine who has the authority as a governing body associated with a desire to follow the instruments that are created under Bill 14?
Minister.
Thank you, Chair. The nations would determine their governance structure.
Member.
Thank you, Honourable Chair. So in a case where two groups of Indigenous people claiming to be from the same nation came and made a claim that they are the official governing body, would the government recognize one over another? Would the government say to both of them, you cannot enter into an agreement until this is resolved? How would the government manage a dispute which undoubtedly will arise between who is the governing body as defined under this Act.
Minister.
In situations like that, we would engage the entities and put that question to them.
Member.
Thank you, Honourable Chair. And where there is no resolution within a nation, as there currently is in many circumstances, how would that impact on the nation's ability to have a governing body that would be able to enter into an agreement under this Act?
Is it possible to repeat the question, member? You kind of faded out at the end there.
I will do my best, Honourable Chair. So, just was referring to situations in British Columbia where there is a dispute between Indigenous people within a nation as to who the official governing body is, and where that dispute cannot be resolved within the nation does not come to agreement. Then does that mean for the minister that that nation would be ineligible to enter into any sort of arrangements that are defined under Bill 14? And it's an important piece to know because the wetsuit is the example I've used, but having had the experience and engagement with First Nations across the province, there are many disputes within nations. Some more vocal, recognized, some not. And there are many, many cases across the province where a hereditary chief has made a claim. The nation itself, or the governing body, or shouldn't say governing body, because that's what we're trying to find here, the elected body, and even other hereditary entities within the nation do not recognize a claim, but a claim has been made. And so I'm just trying to understand how, for the purposes of wildlife management, for the purpose of entering into Bill 14 through the agreements that are in place, how the government would be able to recognize or authorize these agreements where there is a dispute amongst the nation as to who has the authority to be able to enter into that type of an agreement.
Minister.
Thank you, Chair. And many communities have sorted this out, and where they haven't, we wouldn't anticipate being able to proceed with an agreement under this Act.
Member.
Thank you, Honourable Chair, and thank you to the Minister. And that's, that helps certainly in terms of understanding. My concern is there are many nations that have worked it out historically, have resolved this, but because of this government's approach on issues, particularly with the wetsuit, but on some other issues associated with it, there are becoming an increasing number of individuals, hereditary chiefs or otherwise, who are making a claim. Whether they're hereditary chiefs or not, it's not for me to determine, but are making a claim that they are the ones who are the legitimate governing entity of a nation. And so, as those increase, there is the potential for example, if an individual decides that they do not like that a sheltering agreement may be entered into under Bill 14 with the entity that is currently considered the governing body, they make a claim and say, no, you can't enter into that because I'm the official governing body of that area as a hereditary chief or a clan or whatever the case may be. And so I'm just trying to get some clarity from the minister as to whether or not this process can be stymied by individuals or groups that make a claim to be a governing body, or whether the province will have any or will make any effort to adjudicate the value of a particular claim.
Minister.
Well, I have a great deal of faith in the nations in British Columbia, and there are many that have sorted this out. This is about self-determination, and we look to nations to advise us. Many governments, Indigenous and non, have differences of agreements, and we look to the nations to advise us on this. And again, I have a great deal of I feel that nations will be able to work this out. I have a great deal of faith in nations in this province.
Member.
Thank you, Honourable Chair. And you know, I'm happy to see that being the case. And I know nations will make their best efforts to work it out. But I guess, you know, just for clarity then, where a nation cannot work it out for whatever reason within a nation as to what the governing body is, does that mean that the province will not allow agreements or authorities under Bill 14 to proceed?
Minister.
We don't anticipate this, and again, I have a great deal of faith in the nations. This is about self-determination, and we wouldn't be able to enter into an agreement if they weren't able to come to an agreement themselves. But again, I feel that I have faith that would not happen.
Member.
Thank you, and I appreciate that answer from the minister. So the minister is saying is if there isn't agreement, then the components of Bill 14 would not be able to be proceeded with for that nation until such time as they have agreement. And so, if I'm wrong about that, if the minister could just confirm that.
Minister.
Yes, that is what I said.
On clause 2, member.
On clause 2, thank you.
Thank you.
Honourable Chair, and specifically, you know, various nations take the management of land to be quite different. And the example I have talked about at length with the Nakazli Uten, which has a Keo system where each family is responsible for an area within their territory, and obviously those families have responsibility in terms of sort of what would be happening within their particular area of concern. And so, in that case, where for example the Nakazli Uten or Nakazli, yes, trying to make sure I pronounce it correctly, as interested in entering into an agreement that may, of course, you know, wildlife wanders across boundaries. They don't stick within boundaries, so it may go across many different areas. I just want to make sure I've got some clarity that the nation itself would have to determine, and I'm asking the minister if this is correct. The nation itself would have to determine within its own boundaries whatever governance, whatever authority that would be required before they would then be able to enter into agreement with the province, which would then be struck as a you know, be able to proceed. Or would individuals that have authority within a nation be able to enter into agreement with the province, leaving the nation aside?
Minister.
Just for clarification, this is an agreement with nations, not with individuals. And we'll get into more clarity around the specific questions the member is asking about in clause 3.
Member.
Thank you. Thank you for that. We're requesting under clause 2, the governing body of a nation, which means the governing entity of the First Nation, however organized and established by the members of the First Nation. And so there are cases, for example, more recently of the Talazan First Nation, which split apart from one of its original members. There's a group of nations that had first come together. Binshi then split apart, went through a process that took many years to actually create its own entity and have its own authority. And so where we have the grouping of these nations, such as Lake Babi Nation or Talazan Nation or others across the province, there may be desire by a component which may be considered a First Nation, but may be considered part of a larger body, such as Lake Babi Nation, that is interested in entering into agreement. So under those sort of terms, does the entity, the internal entity within a group of First Nations, have the ability as a governing body for their territory or for their people to enter into this agreement, or must it go through the broader body? And I'm thinking in some cases, for example, you may have a situation where a group of nations come together as part of a tribal council that wants to speak on behalf, or currently do speak on behalf. Maybe they call the nation, but there might be individual nations that want to do things differently. And so I'm just trying to understand from the minister how that governing body would be structured in a case like that, where there is a subset that has an authority over land and its own governing structure, but also falls within a larger governing structure.
Minister.
Thank you, Chair. So if there are sub-governance structures that are recognized by the nations, then we would recognize them too.
Member.
Thank you, Honourable Chair, and I have no further questions on clause 2.
Shall clause 2 pass? Aye. So ordered. Clause 3, member for Nechako Lakes.
Thank you, Honourable Chair. So we're getting into now the sheltering agreement, and at the start of clause 3, where guest means a member of First Nation who, under sheltering agreements, hunts in the traditional territory of the host First Nation. There's been quite a lot of controversy over the years in terms of who is a member of a First Nation and who is not. In some cases, it's because of a matriarchal society, a matriarchal lineage, and the federal government has come in with some of the courts have come in with some definitions. So I'm wondering if the minister can provide some clarity in terms of who is considered to be a member of a First Nation.
Minister.
Thank you, Chair. So under Clause 3 of the sheltering agreement, recognition of a member of the First Nation is at the purview of the First Nation.
Member.
Thank you, Honorable Chair. There actually is a great dispute around this, which is why I'm asking, and this is around, somebody who can be a guest. For example, in British Columbia, we have about 250, 270,000 people who identify as Indigenous people in British Columbia. Only a portion of those are actually attached to a First Nation directly. Many, of course, there's intermarriage, there's, a number of things that have happened over time. There has been a lot of disputes in terms of nations and benefits and who receives benefits from a nation. For example, the nation will help out some people for education and for all kinds of things. And so this is a pretty interesting or pretty significant issue associated with this. And so that's the reason for asking the question. I mean, it's clear, I think, what the minister is trying to do here, and I'm just trying to make sure there isn't a situation where this piece of legislation opens up a nation to a particular challenge. For example, because Indigenous people have the right to hunt within their traditional territory, have the right to harvest, even though they may not be attached to a First Nation. And so I'm just wondering how that will be resolved. And so just for clarity, if I heard the minister correctly, what the minister said is that the only way an individual could be considered a guest means that the First Nation would have to have them recognized as a member of that nation. Is that correct?
Minister.
Yes.
Member.
Thank you, Honorable Chair. That's interesting. Is there any means test that is required by the province to verify whether an individual is truly a member of a nation?
Minister.
Thank you, Chair. And further to my other answer, this isn't really I don't understand how this is relevant when it's up to the purview of the First Nation.
Member.
Thank you, Honourable Chair. Well, this bill is put together with the best of intentions, but there is the potential for abuse. And not that, I would make an accusation that would happen, but it could happen. And as we have seen historically, there are occasions where you have leaders that will take advantage of the position. And so, for example, somebody may say, I'm just using a fictitious name, maybe Bob, decides that, some friend of his who lives down in Wyoming is a member of their nation and would be able to enter into agreement as a member of their nation with another nation to be able to go and hunt. And so I'm trying to understand whether or not there's any verification process or any authority by the government to look at this, or whether this is completely up to the First Nations and the province is abdicating its authority for managing wildlife in the province of British Columbia.
Minister.
Thank you, Chair. Sheltering agreements have been in existence for a long time. I have faith in the nations, and again, it's at the purview of the nations.
Member.
Thank you, Honourable Chair. So, answer the question. The answer is no. The province will not have any oversight in terms of that. And, that authority is completely turned over to the First Nation, and that's fair enough. That's what the government has decided to do. But it's just clear to have an understanding of that. So, whoever a First Nation determines is a member of their nation or make a claim of being a member of their nation is sufficient enough for that. Maybe just one other quick little thing just around this is does the individual who is considered to be a guest, meaning a member of a First Nation, does that individual have to be recognized federally as identified as Indigenous?
Minister.
Thank you, Chair. Just to clarify, the member referred to the province abdicating its broad responsibilities for wildlife management under this Act. This is not happening here. The scope of these amendments relates to sheltering agreements, agreements that have been in existence for a long time in this province. And in relation to the last question the member asked, where an individual is recognized as a member of a First Nation for sheltering purposes, it's under the purview of the First Nation, of the host First Nation, as it has always been.
Member.
Thank you, Honourable Chair. Does the individual under the definition of a guest, do they have to be Canadian?
Minister.
They have to be a First Nation recognized, and it's at the purview of the nation.
Member.
Thank you, Honourable Chair. And the reason why I made that claim about this is as we'll get into the session, where there isn't the need for reporting or even following anything that's in the Wildlife Act as defined there. That leads me to that claim. My concern here, though, in the first part of Clause 3 under guest, is that it is completely up to a First Nation as to who they would decide to have as a guest, who they'd like to define as a member of their nation. They could define a foreigner. They could define somebody who is not Indigenous. There is no definition of what a guest may be. And of course, traditionally, that wasn't the case. But we seem to be in a situation here where there is an opportunity, and whether First Nation decides to do this or not through their leadership, I guess is up to them. There seems to be an opportunity for First Nation to be able to look at basically anybody they'd like and recognizing them as a member, and being allowed then to enter into an agreement with another host nation to be available for a hunt. Those rules, we've got rules in the Wildlife Act that prohibit that from happening unless you're a guide outfitter and you have an opportunity to do that. But that's the reason for asking these questions around who is considered to be a guest. And the province is saying, the minister is saying, unless she says otherwise, that there is no oversight, that there is no requirements, that there is no reporting, that there is no declaration that needs to be made. There's nothing. It just allows a First Nation to do what a First Nation wants to do. And I understand the intentions of what government is saying, but there are laws that are in place in this province in terms of our ability to build access on hunting. And this is a loophole to get around those laws if a nation so desires to do so. And I think as a province, we are going a very dangerous path to set up a structure in place to legalize the ability to not follow our laws in terms of wildlife management. And the minister said in her opening comments and second reading on this bill that wildlife is a special place. It's part of the culture of who we are as a province. And this is why I'm going into such great detail on this bill, because it's incredibly important. It is of high value to everyone, whether you live in an apartment in downtown Vancouver or whether you live, out in the, at the end of a road, maybe not even on a road, out in the middle of nowhere, relying on your wildlife for your fridge, to feed your family. We all have this connection to wildlife in this province. It is a very critical part of who we are and what we identify as British Columbia, which is why the Wildlife Act and the importance of managing wildlife is so critical. And so it's disturbing to think that the minister is bringing in this bill with no checks, with no balances, with no oversight, with no need for reporting and no way to be able to do any verification. That is not good wildlife management. That's not necessarily sustainable management. I mean, yes, we're relying on First Nations to go and be good citizens of the province and follow the intent of what the minister is trying to do. And I'm fully sure that many First Nations, if not most First Nations, will do that. But there is now have created the opportunity through this without having any of these verifications in place. So perhaps, I'll just put it directly to the minister with this. Is it the minister's intent to not have any verification process by the government as to who can be a guest associated with Clause 3?
Minister.
Thank you, Chair. And there is no loophole here. I can't stress that enough. There's absolutely no loophole. I mean, this bill was developed with, co-developed with Indigenous nations, and this is a continuation of sheltering agreements. A guest must be a member of a First Nations. If the member is inferring that this legislation will allow members to bring anybody in. That's not what this is inferring. This is guests must be a member of a First Nation. And it is at the purview of the First Nations to accept those guests, those First Nations guests, which are defined in, like we've just spent a considerable time going over what a First Nation means. So it's already, that's been defined. We've spent many hours on that. So it's a guest must be a member of a First Nation. And I just want to make that very clear. This is something that was co-developed by nations. Nations agree on it. This is what they do in their sheltering agreements. This is not about bringing in foreign hunters. It's not about any of that. This is an agreement with nations, host nations, that bring in a guest from another First Nation.
Member.
Thank you, Honourable Chair. And since there's no way to be able to verify whether a guest is actually Indigenous or even a member of a First Nation, except by the claim of a First Nation, then I would dispute what the Minister has just said in terms of this. There is no oversight on that, and it relies entirely on the goodwill of the First Nation who claims a member as a guest. But I'll just give you another example as part of this. I'll just use a fictitious name, Bob, who is a member of XYZ First Nation, enters into a sheltering agreement with a host nation and invites Joe, his friend, to come along and hunt. There's nothing wrong with that. He's invited him to come along and hunt. But there is no way to know or verify that the hunt, that Bob wasn't actually just bringing Joe along because Joe is now going to be allowed to go and hunt, to take an animal out of British Columbia. Or within British Columbia, whatever the case may be. There is no verification process. There is no way that the province is giving any oversight into whom a guest may be and who gets ultimately harvest that animal and use it for whatever purposes that they decide to use it for. And so this is why I'm concerned about this agreement. I'm concerned about the way the whole bill is written, quite frankly, because it leaves many loopholes, as we've already found, associated with the definition of a First Nation to include nations outside of the province and potentially outside of the country, should the courts define that. And now, without any way to be able to verify as a province who a guest is, as a member of a First Nation, how does the Minister expect there to be able to be confidence in this bill in terms of meeting the objectives of good, solid wildlife management, reporting, conservation, etc.? Or, like I say, and in my question that I asked previously, did the Minister just maybe not consider that there could be an abuse of this and potentially set up in terms of having absolutely no oversight in terms of who a guest may be?
Minister.
Thank you, Chair. First Nations can't extend their constitutional Section 35 rights to non-Indigenous peoples. If a non-Indigenous person was coming to hunt on, they would have to follow all of the regulations that they'd have to follow anywhere. They'd have to follow the Wildlife Act. They'd have to follow all of the regulations. So I'm not sure what the member seems to be suggesting something nefarious here. I believe that these sheltering agreements have been in place for many years, and Indigenous nations have managed to undertake them. This is, I'm just, non-Indigenous people have to abide by the laws of the land.
Member.
Thank you, Honourable Chair. Well, I won't go where the minister led in terms of whether Indigenous people should follow the laws of the land as well, but certainly I agree that non-Indigenous people, and quite frankly, I think that all people in British Columbia and Canada need to follow the laws of the land. And that's what we're doing here. We're creating a law. We're creating Bill 14, an amendment to the Wildlife Act, and we're adding provisions in here. And so in terms of a guest, if the province does not have any way to verify who a guest is associated as a member of a First Nation under here, what happens if a conservation officer happens to come across somebody who's harvested an animal and asks the animal, or asks the individual about it, and the individual says, "Oh, I'm a guest." How is it that the person could be verified? I'm a guest under a host agreement. What is the process for verifying that that person is actually a guest within a host nation and that an agreement has been set up?
Minister.
Just in reference to what the member said, all people must follow the numerous laws that we have in this province. In fact, Section 35 of the Constitution Act 1982 explicitly recognizes and affirms the existing Aboriginal and treaty rights, and including hunting, fishing, and trapping activities of the Aboriginal peoples of Canada. And as a result, First Nations have rights to hunt according to their nation's Indigenous laws and governance systems well within their traditional territory. So everyone is abiding by laws. So I took exception to what the member suggested, that this was like a lawlessness in this country. Also, guests will be required to have some sort of permit that signifies that they are actually guests hunting with permission on the traditional territory. And with that, Chair, thank you, Chair. I move that the committee rise, report progress, and ask leave to sit again.
Thank you, Minister. Members have heard the question. All those in favor? Opposed? Carried.
Committee Chair.
Thank you, Honourable Speaker. Committee reports progress on Bill 14 and seeks leave to sit again.
When shall the committee sit again? Acting Government House Leader.
At the next sitting.
So ordered. Committee Chair.
Mr. Speaker, Committee of Supply, Section A, reports resolution and completion of the estimates of the Ministry of Citizen Services, and reports progress on the Ministry of Energy, Mines and Low Carbon Innovation, and asks leave to sit again.
When shall the committee sit again? Acting Government House Leader.
At the next sitting.
So ordered. Government House Leader.
I move that we now adjourn.
Members, you heard the motion. All those in favor indicate aye.
Aye.
Opposed? Motion carried. This House stands adjourned until 10 a.m. Monday, April 25th.